book group sessions has CLE involved in it. So at some point during the time that we're on together, I'm going to give you a code word, and after the session is over, I will send you an evaluation form and also a sign in, sign out form that has a little space to insert that code word. So just listen for that if you want the CLE. We are going to also start this by just introducing ourselves. And as those introductions happen, you can just say your name. And if you have a topic that you want us to talk about as part of the book group, give us the topic and I will put that in the chat, the group chat, so that we all have it. There's no pressure. If you don't have a topic, that's absolutely fine. And of course, today, it's very exciting that we have John here with us, since he's one of the authors of the book that we read and is just a great, I wish he could be with us at all of our book groups because he's wonderful to talk to anyway, but this is particularly special. So we will, this is what we'll do to do the round robin. I'm happy to go first, and then I'll call on someone to go next. Once that person does their name and lets us know if they have a topic, they'll call on someone else. And in this way, we'll get through everyone. So Rebecca Price, and delighted to be here. And I do have a bunch of questions for John that I would say mostly focus on the role of litigation risk analysis for mediators. And I had several questions that have to do with how we contend with helping parties do this, navigating lawyer-client relationships. And I was also particularly intrigued with some of the studies that the book talked about, particularly the ABA study with lawyers and mediators, which seemed to really reflect different perspectives about how much mediators should be involved in decision-making and risk analysis. So those are the topics that I will raise. And I'm gonna call on Mark.
Hi there, I'm Mark Isserlis. I'm a mediator at JAMS. And I don't have anything particular. I do actually have one kind of strategic question when I talk about risk analysis, maybe, which we can get into, which is I'm always groping for ways to deal with the problem that every lawyer, when asked upon to do a risk assessment, believes he or she is 90% likely to win. And so every risk analysis I do confronts that problem. And, you know, it sometimes puts a roadblock in the utility of using it. So I'd be interested in your thoughts on that. Stephen?
Rebecca, is it all right if Mark tells me to go next?
Of course.
Just want to
I thought that's what
Everyone has free agency here. He can call whoever he wants.
I'm sorry, Rebecca. I misunderstood the
No,
instructions.
you didn't. You were perfect. You understood,
okay.
Mark.
Then I misunderstood. Nice pivot. Steve Gilbert. I'm an arbitrator and a mediator. I enjoyed reading the book. I hope everybody, off topic, but important, I hope everybody is safe and all your loved ones are well. Rebecca, you touched on this somewhat. I have my own way of trying to ease into this category of topics / questions, but I was interested in the following, John, and everybody else on the call. A lot of a fair number of the questions in the books or inquiries in the books for eliciting important information are directed to the client. Now, anytime you're asking a client questions, anytime you're asking a client questions, anytime you're asking a client questions, you risk coming between the client and the attorney. Some of the questions are probably going to be asking for information the attorney never thought to ask. So there's the potential for embarrassment because the client's going to say, if not say, at least be thinking, why didn't you ask me the question? The attorney may feel threatened. You have 5 nodes in the room in a minimum: attorney A, attorney B, party A, party B, or decision maker A, decision maker B, and the mediator. And there are all these relationships. If you draw the lines, you know, there's a bunch of relationships, but 10 for 5 nodes. And the mediator is supposed to be mindful of all of this to not cause problems. So the general topic is, how do you elicit the information from the client to get, when I say client, I mean the decision maker, but it could be an individual, without causing a problem between the attorney and the client, and also to try to get the best information you can from the client. So it's a large category. During my pre-mediation call, which is typically only with counsel, I make it absolutely clear that I have no desire to come between an attorney and the client, and I remind them of that. And I also ask them, and I may have it in my email summarizing the call, that says, I hope that if a time comes when I want to talk to the party alone, I'm hoping you'll grant that permission. I don't recall doing it except once or twice when the parties and the attorneys asked me to do it. Okay, so that's the setup for this. I think it's an important and somewhat large category.
Okay, Steve, so call in whoever goes, Ansley, Jackie, or Michael.
Okay, Jackie.
Good morning / afternoon, everybody. Thanks for having me. I guess I really agree with Stephen. Maybe what was also said by Mark.
I'm having a hard time hearing you.
Yeah. Can you speak up a little, Jackie?
Oh, can you hear me?
When you're closer, it's a little better, but it is sort of faint.
I'm not going to add a topic, but I agree that it's always, I always think it's fruitful to get the client to talk, but I recognize that it's sometimes difficult to have the lawyer become comfortable to let the client actually express themselves. But in my practice as a mediator, I think it's incredibly powerful if the client talks. Even if they're upset, even if that's something the other side doesn't want to hear, I think you get to the nub of it. And I think it's very important, but I recognize, as Stephen said, sometimes that can be a clumsy position as a mediator, because invariably the nature of your questions or your follow-up might lead someone to believe that you're taking a side, or you're focusing on maybe a weak spot or a strength of their case. And all I can say to Stephen's request is I constantly say, I'm going to do this with the other side. I promise you. Talk to them also, and try to reassure them that it's something I will do bilaterally, if I'm invited to do it.
Great. Go ahead, call on either Ansley or Michael.
Ansley.
Great.
Hi, I'm a 2L at Cardozo, and I'm interning for Rebecca this semester. And I'm excited to hear what all of you are bringing up in topics that have been discussed already. Being able to observe mediations has been really interesting, and seeing the ins and outs, and especially different styles, I think has been really insightful for me. So I'm excited just to participate in the conversation and hear what you guys have to say.
Great.
And I think Michael's left.
Yeah.
So I'm a mediator arbitrator with the AAA and various court panels, and I have no specific question other than I'd be interested to hear about how this framework for analysis has worked out in practice for you with different, cases.
I guess I'm next. Hi, everybody. I'm just thrilled to have a chance to have this conversation with you all. I want to give a little background about me and my connection with Rebecca and the book. I was on, and still am on, the publication board of the ABA section of dispute resolution. And at the time, Rebecca was the chair of the publication board. And this was several years ago. And she said, we're always looking for new books. We're coming up to the annual conference of the section. Keep an eye out for possible book topics, possible authors. So I went to a session with what turned out to be my co-authors, and I thought it was very interesting. They'd done a lot of research on litigation risk assessment, And so afterwards, I sent an email. I knew one of them, Michaela Keat, somewhat, and so I wrote her, and she and her colleague, they both teach at the University of Saskatchewan, got back to me and said, yeah, we're interested and we'd like you to co-author it. And at that point, I had been retired from teaching already, and I did not want to undertake any more major projects, but this seemed very appealing to me. And we combined work that they'd done on litigation risk assessment as well as work that I've done on early dispute resolution, and turned out to be a wonderful collaboration, and a wonderful collaboration with Rebecca, who was still chair and shepherded us through the process of negotiating the contract and managing the book process. So that's a little background about how the book came to be. You know, I'm interested in this conversation in part because, you know, I'm just a pointy-headed academic sitting in my ivory tower all the time, and you all are out there in the trenches dealing with cases. So I'm actually looking forward to learning from you as well. And, you know, we have our ideas about what, how, you know, what makes sense, but, you know, knowledge is a continuing evolving and growing thing. And so, you know, it's a continuing education process. I have had experience as a mediator. I graduated from law school in 1980, hated practicing law, took a mediation training in 1982, series of them starting then, developed my own law and mediation practice, did mostly divorce mediation, although a variety of other things. And then eventually went on to get a PhD in sociology, and then have been teaching since 1995, although, as I say, I retired from teaching in 2015, but everyone teases me that I'm the most active retired person they know. So I'm not sure, is there anything else that would be helpful for me to say at this point, Rebecca?
No, that's great. I think that's great. If you want to, in no particular order, John, I put everybody's queries in the chat, and then I'm sort of dropping in my questions as well. So I would say you should just start wherever you want to start. And obviously John is here because he's contributing all of his expertise from the book, but if others have perspectives too about any of these topics, there are certainly things that all of us are contending with. So, but John, why don't we start with you?
Yeah, and actually, why don't we do it this way? Why don't we take sort of the questions in turn, and, you know, I'll give my take on it, and then everybody else can weigh in on it. Again, you know, you all have a lot of expertise in a way that I don't. So I'll tell you my take on it. So let me start with Mark's question. There are a couple things I can think about in terms of ways to deal with this. One is, actually, I had a conversation with Peter Phillips, who is in your neighborhood. Some of you may know Peter. And he was talking about how, you know, he, as a mediator, you know, he will have the experience that you expressed, Mark, that, you know, he'll ask people the lawyers, their expected probability of winning, and they add up to well over 100%. And so one of the things that he can tell them is that, in fact, that's one, normalizing this process, that people tend to be overconfident, or at least that's what they present to the mediators, and that you know, he knows from experience, this is, he didn't say this, but I think that you all can say this, that, you know that lawyers have their own private assessments that may not be exactly what they present to the mediators. So in their heart of hearts, if you gave them truth serum, they probably would give you a somewhat lower probability of winning. And then the other thing that I think is really helpful that struck me is this series of studies you may be familiar with, and of course we summarize them in the book, showing that in an unbelievable number of cases, one side or the other ends up with a worse result at trial than the last settlement offer. And the research studies don't even consider the tangible or intangible costs. So, you know, let's just say you get a $100,000 settlement offer as a plaintiff and you win a verdict of 99,000, well, you know, you're down 1,000 in out of, you know, the tangible results of the verdict, but then you also have the time and money and grief, all the intangible costs. So, I mean, if you factored in the tangible and intangible costs, the results would be a lot higher. So I guess one strategy to address what you're asking about, Mark, would be to say, you know, there's this research which shows that, you know, a lot of people make mistakes. And one of the things, particularly for the lawyers, you know, this is a really bad result for them. So, you know, if they get a settlement offer from the other side and they advise the clients to not to accept it and they go to trial, and then they get a worse result at trial, they have to face an unhappy client who is saying, why the hell did you advise me to go to trial when we could have saved a lot of money and time and grief? So I guess those would be the sorts of things that I would be saying that you know, a lot of people are overconfident, and we know you know, from the heuristics why that's so, and that there's a risk to you and your client. And you know, we can talk about, you know, things that you think are you're more confident about, and maybe things that you're less confident about. Some of the things that I think that are standard mediation techniques. So those would be the things that I would think about. What do you all think?
Yeah, Steve?
I just wanted to ask a question. One observation is just to say, to start off to an attorney, whether or not his or her client is present, and say, are you familiar with the research that, I'll paraphrase now, that in essence shows you're probably wrong? Most people are not going to react well to that. And to ask the question in front of the client is even worse, because now you're potentially embarrassing the lawyer. One thing you did say, which might be helpful, I could see buttonholing the attorney separately and saying, look, I'm not taking sides. I told you I'm absolutely neutral on this. I just want to make sure you're aware of research. I'm not saying this applies to you, okay? Because you certainly seem to know what you're doing, or whatever, however you want to fluff it up to soften it, and then say, there is this research that shows, is there, and in your most sincere, concerned face and voice to say, are you absolutely sure about this? I don't want any of the attorneys here to be embarrassed. That's one path I see for possibly disclosing that research, to try to soften the attorney, but I'm sure other folks on the call have more ways and better ways of doing it. So I'd be interested in hearing how you bring that to the attorney's attention.
Mm-hmm. Jackie, yeah.
Well, I probably wouldn't say it, but I certainly wouldn't believe it. I think an attorney who says in front of their client at mediation, oh, if we go to trial, I have a 90% chance of winning. I probably, and Stephen, I understand the sensitivities of lawyers, but I really don't like talking to the lawyers alone, because I don't think that's the ultimate decision maker or the ultimate audience. But I would probably say something, if we have gotten through like the facts and the law of the case, and I'm sure all of you do this, then you fall down to the process. Okay, attorney, what is a win? What does that mean? Can you explain to your client what are the steps between this mediation and a win? You know, whether it's summary judgment motions, waiting for that to be done. Most courts, even after a summary judgment motion or while it's pending, will probably have some other settlement conference, either with the magistrate judge. In state court, you go to a settlement conference that's mandatory. So I try to deputize the attorney to take his client by the hand and walk him through how you get to that win. How do you cross that phase? And I think that that's sometimes very helpful, because of course the next series of questions is, and how much does it cost to get?
Mm-hmm. I think this is a really hard, as Mark said, I think I have to say, in the last many years, I have stopped asking this question about likelihood of winning. I mean, mostly because I think it sets up this strange dynamic where the lawyer has to, in some respects, to maintain their relationship with their client, they have to sort of, at least on the face of it. Sorry, a little bit of a detour, but relevant, is that I was actually, I had the pleasure of being a Zoom assistant for one of the mediators last week. And it was, which was great. And one of the things about that case that was really remarkable was the plaintiff's attorney was the opposite of what we're all describing. So he was saying to his client in front of the mediator and with me there as a fly on the wall, I've already told you you're not going to win on this claim. Right? So here's why your request to the mediator that she go in and make this demand on this particular claim is going to backfire. So, and he was being so candid, and I was, it's so rare. It's just so rare. And in fact, what's more frequent is that a lawyer might be candid with me as the mediator, but almost inevitably when we get in front of the client, that goes away. So I really don't ask this question anymore. I haven't found it to be successful. I started to ask it early on when I started to work in the court, in part because Andy Little, who's somebody who wrote a book called Making Money Talk that many of us have read, has a whole series of questions related to lawyers' estimations of win and loss that I thought were really interesting and useful. But every time I asked it, this is what I got, 90%, 100%. And then I would have to default to, which is actually what I do now somewhat without this question, which is, you know, I believe that you and your client are here to try to resolve this case because there's a universe in which it really makes sense to do so. So regardless of what your estimation is of what's going to happen when you go to trial, that's far off. And our task for today is to try to see if we can get this done. So in that way, it sort of almost doesn't matter. And of course it does. If somebody thinks they have a 100% chance of winning, why would they? But all the reasons that John just articulated, which is you could have a 100% chance, like on a wage and hour case, which many of us do. It's basically a strict liability statute. The plaintiff's almost always going to win those cases. But having the conversation about opportunity cost, and it's fee shifting, right? So they only have to win on one claim in order for them not to have to worry about attorney's fees. But there are a lot of other minuses on that ledger that make it not that appealing often to go to trial, even when you have a 100% chance of winning and a 100% chance of getting your fees, at least some of your fees, paid for by the other side. So, you know, anyway, I guess that's a long story to say I don't ask this that often anymore. I haven't found it to be effective. But if I were going to ask it, I'm in Jackie's camp, which is I would ask it in front of the lawyer and the client together, unless I thought there was something really funky happening, because I would want to have the conversation with everybody. And I'm not as worried, Steve, as you, that asking that question is going to create a fissure. I think if you are there genuinely and you're there in a helpful way, I think that's usually the perception. They don't experience the question as a kind of attempt to sever the two. It's really, we're in this together. Let's try to do this in a real way.
Rebecca, does the fact that you don't ask the question directly, does that mean that you also, as a consequence, won't walk through sort of like a probability kind of risk assessment analysis with them?
Sometimes I do. I mean, if they bring it up, right? So if they say, for example, we're going to make this motion, right? And here's here's how the thought of making this motion is impacting what we're putting on the table today, then I would walk it through because they raised it. And the other thing that I have done, which is not quite this, but I've done a number of cases that are 1983 cases where there have been very serious injuries or death for the plaintiff. And in those cases, it's not the risk assessment about win or lose, but it's both sides go get me the comparables on which you are basing your demands and your offers in this case. Like, let's take a look and go do that research. And then we look at it together. And that's been very helpful. That has nothing to do with this, who's going to win and who's going to lose, but it's for the purpose of settlement. Let's get this data. And really, you know, is an $11 million demand in this case, where does it fit with all the other settlements and all the other verdicts?
Yeah.
So.
I wanted to comment about a couple of things, and I won't remember them all, but I guess I think that in a lot of ways it makes sense, as Rebecca was suggesting, not to ask for the numbers, because in some ways it's asking for trouble. In some ways, one of the things that I think is implicit in a lot of the mediations is the only thing that's important is what would happen if you went to court. And part of what I have come to really appreciate more and more, having worked on this book, are these other two factors, the tangible and intangible costs. And so focusing on the bottom line, the bigger picture, is to me a helpful thing. Now, for lawyers, that may not be where they're at, and they're just thinking about, well, what would happen if I went to court? And I guess, Steve, you were talking about and concerned quite properly about the dynamics between the lawyer and the client, and between the mediator and each lawyer-client pair. And so obviously mediators need to be very careful and sensitive. And you've described, you know, a way that I think many mediators sort of generally approach wanting to be respectful of the lawyer and indicate that they're not trying to go around the lawyer. I remember when I wrote my first article back in the 1990s, this is when I was in Florida, and it seemed kind of weird to me, maybe not to you. The mediator was, this is some CLE kind of thing, he was saying, sort of describing how he would, in a caucus, turn to the lawyer and say, would you mind if I talk to your client? And what this was a reflection of is that sort of the client is this fifth wheel, the secondary person who, it's really the lawyer who's the important person there, and they're going to give permission to let their client speak. And I understand the dynamic and the reason why lawyers are very wary and cautious and worried that their client is going to do something to screw things up, even in a caucus. And so having the kind of conversation that you're describing and saying, well, let's have a good conversation together would be a useful thing. And you were talking about asking about, you know, raising the research. And I guess I would be thinking about sort of normalizing and saying, look, you know, this is about lawyers generally, and maybe you're the best lawyer and you've never made a mistake, and you're always right. But I can tell you that this research indicates that in over 80% of the cases, one side or the other makes a mistake, and here are the consequences. And, you know, and maybe, you know, 90% of the time you're right. Maybe this isn't one of those times. You just can't know that. And I'm kind of rambling on. You would say it in a much more tactful way, and that the idea would be, you know, we're trying to think about how you can get the best result for you and your client. And so that's the conversation that, you know, I'd like to have and think about. And one of the questions in the appendix talks about, you know, you have, you know, most lawyers have more confidence about some issues and less about others. Let's talk about, you know, each of those. And I suspect that mediators often do something along those lines to help sort of probe the strengths and weaknesses of the case. And that may help some. I don't know.
I guess I found that I'm able to make the most use out of a kind of risk assessment analysis when it's clearly a fact issue that's going to go to a jury. So, because there I feel very comfortable kind of reality testing, debunking an overconfident 90% with a kind of statement that says, you know, or a question like, this is going to the jury, right? And like, you know, it's really hard. You know, there's lawyers and clients, I think, buy into the notion that there's an inherent kind of randomness, arbitrariness to what a jury is going to do. Whereas when it's a legal question, that's when it's really hard for me, because when I'm doing this assessment with the parties, I don't yet want to weigh in and say, no, I think it's a 60% case or a 70% case in the legal question. And that's usually where the lawyers are the most confident, right? Because they feel they know the law, they're right on the law. And that's what that's much harder for me. So when the lawyer says, yeah, we're 80% going to win the summary judgment motion, there's something I can do with that. But I feel I can make a lot more progress on a clean factual question, getting people to buy in that it's a coin toss. Okay, so it's not a coin toss. So maybe you're 60% likely to win, right? And then we can make some progress.
Well, let me actually suggest a variation of this, which may or may not be helpful for you all. And again, some of you may do something like this and say, well, you know, if you tried this case 100 times, the results would not be the same 100 times. You'd probably have results that would look like a normal distribution curve. And maybe if you're really confident, you'd have a very narrow, tall curve, and most of the results would be falling within a very narrow range, but you'd still have these tails that go out on the end. You just don't know. Maybe you'd really win a lot, maybe you'd really lose a lot. Also, it's possible to have tails that, you know, have a curve that's pretty low and flat. And one of the things, you know, you can be very confident, but you just don't, you know, life is a crapshoot, it's uncertain. And that's true, I would think, both about the facts and the law. Now, you know, I don't practice the way you all do, and maybe that's a harder sell. But in some ways, if you look at it globally, regardless of whether it's the facts or the law or the weather, you know, the results are just uncertain. And that really what this is about for a lot of them is risk management, is saying, okay, we don't know what's going to happen. And so you're just trying to make the best bet you can. And usually we know that most cases settle, and in large part because there is so much risk. And so the question is, how do you want to manage the risk, and how much risk are you willing to take?
John, I love that question too, and thinking about if you tried it 100 times, what would happen. And one of the things that I've always wondered about, in terms of how that plays to people, you know, is that, you know, the comeback, sometimes they say it, sometimes you feel it, is we're not going to do this 100 times. Right. In other words, right, it's like a one-off in some sense. If you're really making repeat decisions over time, that kind of distribution curve analysis is very impactful, right? But if you're just doing something once and only once, like flipping the coin, right? I mean, it just, I don't know, I feel like it shapes behavior less because they feel like they're doing it once.
Can I just briefly respond to Mark?
Yeah.
When I did an interview for my doctoral dissertation, I remember interviewing this lawyer who said, you know, if I tried 5 cases in a year, which of course is inconceivable these days given the trial rate, you know, and I lose one, you know, I get an unexpected result in one, you know, I understand, I can live with it. For my client who has only 1 case in a year or 1 case in 5 years, that's a bad result. And so, you know, in some ways you could flip the question back to them and say, you know, we're only going to try it once, and maybe you're going to get lucky. Do you feel lucky, kid? Do you feel lucky, punk? Or, you know, or maybe you are going to get really unlucky and you're going to be facing, you know, Clint Eastwood. So that would be one way. I'm sorry, Steve, you were going to say something.
I was going to say something along the same lines of saying Russian roulette.
Yeah, in some
There's 6 empty chambers. You put the bullet in one. Your odds of surviving after when the trigger's pulled are, you know, 84%, give or take a little. But you might be unlucky. You might be unlucky and come up with that. So you're at the tail of the curve.
Yeah, in some cases, the uncertainty is not so much whether you're going to win or lose, like wage and hour cases. It's whether you're ever going to collect. And so that's much less predictable on the basis of experience. So, you know, I guess the uncertainty, you use whatever uncertainty there is to try and sharpen people's thinking, but it's different from case to case.
And that's a really good point, Michael. And in our book, I think we have language along the lines of that there are all these other uncertainties. It's, you know, as you well know, just because you get a trial verdict doesn't mean that you will collect. One of my, I don't know, favorite is maybe not the right word, stories. When I started working, I worked for a lawyer and he lost the trial, and he was, I guess, representing the defendant, and I assumed naively that the client would immediately whip out a checkbook and write a check for the amount of the verdict. But no, the lawyer went to the other side and said, we'll give you half if we don't file a notice of appeal. So, you know, there's all sorts of things that the verdict isn't the end of the story. So, you know, collecting bankruptcy, all sorts of things, you know, and there are also intangible costs of, you know, continuing after the verdict.
So John, should we move forward onto this? We've talked a little bit about the Steve and Jackie's question about talking to attorneys and or clients collectively, and you've said a little about that. I don't know if you have more to say, or if you want to also move forward to Michael's question about sort of real life cases.
Okay, well, let me just briefly address that. I mean, I think I've already addressed it to some extent. My sense is that I guess I would just say, you know, I'm sure that you've talked about a lot of things. Part of the reason, you know, you're here because you've not been able to settle so far. One of the things that you're looking for from a mediator is to help you think about things in different ways. So I'm going to raise some questions that you may not have considered. And this is a chance for you to discuss them. And you may want to discuss them together with me, or you may want to discuss them privately, and then we can talk about them all together. So I don't know, how does that sound?
Are you asking Steve and Jackie and or Jackie? Anybody. I mean, it sounds good to me. Yeah. It sounds good to me.
And in terms of real life, damned if I know. You know, I'm just a pointy-headed academic. What we did here was essentially stitch together lots of different things. Michaela and Heather have done a lot more of the work on this, and in some ways, part of what this is just being more systematic about things that I think lawyers and mediators do less systematically and less explicitly. And I don't know that anybody would ever whip out a copy of the book and say, okay, it says here on page 25 that I do this and that. So that they're not going to be following this procedure. And part of it is that what we talk about is that this is a general approach and that people need to be tailoring it. So and this is one of those things that I think would be really hard to be able to do an empirical assessment and say, well, gosh, people are doing this and this is what the consequence would be. So that's probably not a very satisfying answer, but if you give me more time, maybe I can make up something better.
Well, I mean, John, don't you think there could be an empirical, I don't know, empirical is very hard, but some kind of a study where you take some cohort of mediators who do a multi-stage process, the first stage of which is sort of assuring that the attorneys and clients have done a litigation risk analysis before the formal mediation commences. And whether or not, obviously you couldn't know the kind of depth to which that was done or the kind of proficiency with which it was done, but you could get some kind of a sign off that at least everyone has made an attempt at it, and then sort of track whether or not that stage in those mediations, you know, led to any kind of different resolution rates than like a control group where they just come in with whatever they've done.
It wouldn't produce data that I would find very persuasive.
Because you don't know what they would be doing with their clients?
Well, because there's just too many variables. I mean, one of the things is, you know, I think I'm burdened by the fact that I have a PhD in sociology and I know something about social science research and the limits of social science research. And, you know, I think that there are a lot of people who, you know, aren't so burdened and have an assumption that, you know, if we do a study, we'll find out the truth. One of the things that I thought was very compelling is there was, you may be familiar, I think we included, yeah, I know we included in the book, the research from the more recent task force on mediation techniques. And, they, on basic stuff like, evaluate whether mediators are going to do what is categorized as evaluative, which they can't even come up with a consistent definition of. You can't find consistent results, and in order to I mean, if you did, in order to really know, you'd need to have robust replicated studies in a variety of contexts. And so I could go on in greater length. That really isn't worth it. All this is to say, I think it would be helpful. I mean, these are things that, again, that people are doing piecemeal, and some of them may be doing it systematically. It's hard for me to imagine that it would hurt or that it wouldn't be somewhat beneficial to be more self-conscious and more systematic. Whether it would produce, statistically significant improvements in some measures, I think it probably would, but I don't know that people are doing stuff like that. So I'm rambling on. I will stop there with my rant.
Rebecca, it's very simple to run a study. Get half of the Southern District panel to read the book and follow the procedure.
Right,
Tell
exactly.
the other half they can, and at the end of a year, see who had a better settlement rate.
You read my mind. You read my mind.
John, doesn't that do it?
I didn't think of that.
Michael, did you have, you're muted. I don't know if you're muted right now. You have to unmute yourself. There you go.
In terms of, the empirical evidence, I was thinking less of a controlled study than, practical experience. For example, I'd be curious people have gotten when they suggest to parties. When they suggest to parties,
You're better now. It's better now.
They suggest to parties, how about a two-stage mediation? Have you ever thought of that? Because one thing that I'd be curious about is how many parties think, oh, I know what this mediator is trying to do. He's trying to increase his fees by having 2 days of mediation rather than 1 day of mediation. So since that's a novel idea, I just wonder how, as a practical matter, the sales or the suggestion goes over with parties.
Well, I will tell you that I wrote a short article about this before we put it in the book, and it was a blog post, and I sent it around to a number of people who I really like and respect, various mediators, some of whom you may know, who said, some of whom may even be on this call, who said, this is an interesting idea, John, but I'd never do that. So it never got published. Actually, I drafted originally as an article for the Dispute Resolution magazine, and it got rejected. And then I posted it as a blog post. And I think it was mostly dead on arrival, just for a lot of reasons that people just were wary about doing that. That said, I think now that we have the need to do stuff by video and people aren't traveling these great distances, I think there's a lot of potential. I wrote another blog post. I don't know if you forwarded this to them.
I did.
Okay. That there were a number of mediators, including, actually, Mark, you were one of them, weren't you? Yeah, well, I thought your name was familiar. So you should be talking about that, not me. So, I mean, it makes perfect sense, but then again, so many of my ideas make perfect sense to me, and for some strange reason, not everybody agrees. So, Mark, tell us about your experience.
So it's interesting, that little piece I wrote. I did it before really having done much, if any, kind of Zoom mediations. So it was really more of a concept. So I can empathize with the ivory tower kind of. I had this concept like, oh, this could be great, and I wonder what it would look like. And then at the same time, right before it came out, parties called me, and one side wanted to mediate in person, the other side wanted to wait to see if we could, it got all very confused. And I was able to sort of, as I was drafting this article, say, what if we tried this, and tried a couple of Zoom, and then we could maybe we'll be able to meet in a month. And so I was able to test it out, and doing these virtual caucuses and splitting mediation up into parts. And I've done it now, I guess, in 2 separate cases. I have been very constrained, aside from the article, Michael, in actually pitching this to people for the reason that you said, because I've always been suspicious that people will think I'm trying to turn 1 day of mediation into 3 days of mediation, especially at jams rates. So if people want to do it, it'll be great, but I'm not trying to push it on them. The other thing that I found is, like, the main point I was making in the article was that there's pros and cons of the 1 day mediation in terms of the time pressure that's put on people, right? And the good thing is that it focuses everybody's attention. You're there for the day, you get it done, everyone's incentivized. The bad thing is you sometimes run out of time and you feel really rushed, and people get very anxious because they feel rushed, and then they're waiting for 2 hours. You come back, and how could you leave us for 2 hours? It's 3 o'clock. We haven't had any numbers yet. And the thing goes, sideways because you have such limited amount of time. So I thought, well, wouldn't this be great if we could sort of slow down that initial caucus session and really take our time with it and then negotiate at a later date? That was my insight. And so what I found in practice, actually, the 2 times I did it, is that when, especially in an emotionally kind of charged case, which is most cases, if you give a party kind of unlimited time to tell their story, they will tell a very, very long story. So, like, I had set up a 2-hour kind of video caucus session with the plaintiff, and it was like 4.5 hours. The same thing happened with the defense side, where I didn't do anything but kind of ask open-ended questions, tell me more about that, help me understand, no reality testing, nothing, just that first kind of caucus. And it was really like 2 4-hour sessions. And, there was a sense in which it was great because I felt that I wasn't rushing them along and saying, because I always feel like I'm steering it in some way because I'm mindful of time. So I love not having that pressure. At the same time, it didn't need to take 4 hours. And maybe it was good for them in a cathartic way, but it was way too long, and so.
So in the upshot, and did those cases settle? Did you think it was a good process? Are they still pending, or are they done?
So the first one that came along got settled, and we did a few long sessions separately, and then we met for a Zoom session where we were all together on the same day. And I actually think it worked pretty well because we had gotten a lot of the preliminaries done, and we met a second day and we got it done. The other one has been in a kind of time warp of, a couple of private caucuses with each side, and then getting people to then focus on getting it back on the calendar. That's another real trick when there's no time. If you have people incentivized to settle on both sides, it's not a problem. But if you don't have that and there's kind of partial buy-in to the process, the time lag and then getting the next one scheduled, and then the other side doesn't really know when you're meeting with the other side, and so I think I'm worried in this other case that it's going to just fizzle out, and so I've now started saying to the parties, okay, we did this a couple of times. I know you never wanted to get together for a traditional session. Now we can't, but maybe we should meet on this date and just see if we can negotiate a deal or not. Because I feel like if we don't have that focus at this point, it'll just fizzle.
I have a couple of thoughts about how to possibly address some of the challenges that you experienced, Mark. And I'm curious if you and others, what you think about how this might work. First would be to actually plan a schedule so that, that it's, we've got 2 hours with plaintiff and 2 hours, on this day, 2 hours with defendant. And then maybe I'll meet together with the lawyers, on Wednesday, and on Thursday we'll have a joint session or whatever, so that you have this schedule set in advance. It's not sort of ad hoc as you go along. Another thing that would also possibly do would be to set sort of time limits for your talkative parties who may be plaintiffs, but also I know the defendants also sometimes, who knows, they may even have some feelings. Even insurance adjusters sometimes have feelings, So that might be a way of doing it. Part of it also may have to do with your sort of billing structure. I don't know if you bill by the hour, the half day, the full day. If you break it into smaller pieces, then they may not feel that they're paying for as much. And in some ways, it could be more efficient. In some ways, it kind of reminds me of Frank Sanders' comment about settlement counsel, that only lawyers could come up with this idea that you could save money by hiring 2 lawyers instead of 1. That if you break it up into more sessions, instead of having these long sessions where people are sitting for these long caucuses really feeling like they're not being productive, that could be a valuable piece of it as well. And then the problem about the parties going on too long, this reminds me of what I would talk about in class. And so, how you do good listening. And so part of it would be to say, after they've told their story and then they start repeating and saying, sort of doing the good summary and then saying, okay, I got that. Is there anything you want to add to that? And then, of course, some people will get the message and they'll say, no, I think you got it. And some people will just go on. And then you need to be prepared to segue into, well, I understand that. And I have time constraints, you have time constraints. So we need to be kind of moving along. I really hear what you're saying. And I understand how important that is to you and why that's so, so significant. So, that's easy for me to say. It can work in some cases, and in some, this is just, that could happen in a one-day mediation as well, where you're in a caucus with a party and they're wanting to go on, and and in some ways you may have even greater problems because of trying to get it all done in one day. So anyway, that's my reaction. I don't know if you think that would work.
Yes.
I've taken on board what you said. I need to check in with the other side.
Yeah.
Oh, so when you're in a live session, like, yeah, Steve, that's like the go-to move. Like, I'm just, I'm even okay checking my phone the time, and I say, look, we could spend here all day. The other side's waiting, especially if it's the defense room. I can say, you know what, if we want them to pay you some money today, I should probably go spend some time with them, make them not feel so lonely. So it's great. But when you're just on a private caucus,
right,
in an asynchronous setting, you lose that excuse, So one way to do it, I love, John, the idea of like, just, I scheduled it for, I don't even know if I had an end date, an end time. It may have been a 4-hour session, but I said, we'll go as long as we need to, but maybe I should just say a 2-hour block. And then I have my own excuse, right? Which is I'm sorry, I'd love to talk more. I got to stop at 10 o'clock. We can set up another one if we need to. So that, I think,
you can say the dog is eating your homework.
And one of the things that mediators often do is being time managers and say, okay, we've done this, and I want to use your time as effectively as possible. So I hear that. Let's move on to the next thing. And also point out, if we've scheduled it for 2 hours or whatever, the time is coming up. We've got a half an hour before then. How can we use that time most effectively? That's something that I've used a lot, and I think that's worked.
Yeah, those are great suggestions. Another thing that came up, and then I'll pass along, all the goodwill you generate in that initial caucus by being understanding and asking open-ended questions. And the lawyers told me afterwards, especially the 4-hour session, that it really worked. This was someone who didn't know if she wanted to mediate again. He said she really felt like she bonded with you, like you really heard her out. So I was like, great. I did what I wanted to do. Then 2 weeks went by till I came back again, because then I talked with the defense side, and I came back. And, you always worry about when you have to shift into reality testing mode, that people will feel like, where'd my friend go? Like, who is this new person? This is a very, but I felt like that problem was actually made worse a little bit by the delay in time, because they forgot how understanding I had been at time 1. And then I came back at time 2, and I started out, I tried to sort of say, like, thank you so much for the last time. And it was really helpful for me to hear what you had to say. And I did that with the other side, and now trying to shift it into, I'm going to ask you some hard questions, which I didn't say it that way, but that's what it felt like pretty soon into that second caucus. I feel like a lot of the work I did in the first caucus was lost to the time lag,
So again, just sort of elaborating what I was describing before, you know, I think in the presumably you have a conversation with lawyers ahead of time. And so if you do that, part of what you can do is, you know, set up a schedule and say, okay, I'm going to have a 2-hour session with plaintiffs on Monday and a 2-hour session with defendants on Tuesday and whatever, so that you and jointly plan that and you know, and learn from this experience that you don't want to stretch it out too long so that they forget.
Yeah.
Yes,
Rebecca, is there another topic, or John? I don't know if I should be addressing the question.
Well, actually,
is there another topic? Because there's another topic I'd like to add to the list, and I don't know.
Yeah, you can add it. I have
Okay.
a couple of questions of my own as well.
Okay, quantifying intangible costs. I realize that very often I have not spent enough time asking questions like, are you losing sleep at night? You know, I'm not asking that, but that's reducto ad absurdum, but maybe not. And the one technique I remember from reading the book was questions along the line of where the intangible is XYZ. What would it be worth to you if you didn't have to deal with, or you could postpone or avoid or get rid of XYZ? Are there any other techniques you know, or approaches you know, for getting people to focus on quantifying intangible costs?
Well, one of the things about intangible costs is that they are inherently subjective. So, you know, you have the exact same set of facts and the exact same law, and you have two different parties, two different plaintiffs, and one is going to have a different risk tolerance or patience or need for money or all sorts of things. And so it's inherently subjective and it's inherently personal. And so I guess it's really a question of saying, what's it worth to you? You know, and different people are going to have different reactions to this. And, you know, it's, you know, my job here is to help you think about, you know, what your best decision is. I'm here to help you make a decision that's going to fit your life as well as possible. You know, some people are really so afraid of going to trial, and other people really aren't. They're really, you know, they're looking forward to it. I remember for one study, I interviewed a lawyer, and he was describing how, you know, he had to settle for, and his client had to settle for a lot less because his client just could not tolerate the continuation of the litigation. And, you know, others just, it's like, you know, let me at them. You know, I can handle the truth. I'm looking forward to my day in court. Now, a lot of, you know, parties may say that they're wanting their day in court, and then they get close to it and they kind of chicken out, but some of them actually really would like it. So the short answer, my short answer to your question is really, you know, saying how much is it worth to you, and putting a dollar figure on it is important, because if you don't, then it's easy to just overlook it or not credit it. And you know, when you put a dollar figure in doing this bottom line calculation, which we think is so much more important than focusing on the BAT note, what the actual result would be in court, is it's an exercise to help them do some reflection about what they want to do or not, and what their limit is, what their tripwire is, really what their own, you know, their limit to being able to settle. And they may not, and of course a lot of mediators talk about not wanting to ask parties bottom lines, and I think that that's a wise thing, because they change and they're not going to be candid and all that reason. But to just say, you know, you reflect on this and think about what it's worth to you. So anyway, that's kind of what makes sense to me. I'm not sure I have more questions than we have in the book. And obviously, you know, as we said, you have to use your judgment about what questions make sense for you as a professional. You may not want to ever ask about, are you losing sleep? Or you may want to ask that only to some parties who may, for example, give some hints or say that. Say, gosh, I've been losing sleep. And you might want to follow up and say, well, how often? You know, how much of a problem is that? Is this a serious concern for you? So, I mean, part of it is just being a good listener and picking up on the cues that the people are giving you.
So I guess the short answer to the question is the question after you find out what all those XYZs are, losing sleep, causing problem with your significant other. I had a commercial case where a very famous lady owned the business and her husband owned nothing in it, but the litigation was ruining their home life. So he was in the room. We got him in the room, and it was important he'd be there. So I guess the short answer is that after you've listened carefully and found out what all the XYZs are, the best by far, and maybe the only question is, what's it worth to you to get rid of all the XYZs?
That's exactly right. That's
Okay.
exactly right. And it's hard to know what all of them are and why I mean, from my perspective, the most valuable part of the book is highlighting these intangible costs, which I think that many lawyers and probably mediators overlook. And it's not surprising that mediators would, because you don't have the same time and access to the parties that the lawyers do. But there are just an awful lot of them. One of the things I worked on this other project with Peter Benner, some of you may know him, he's a mediator in Connecticut, and we were looking at corporations and why they didn't do planned early dispute resolution. And one of the things that we found was that a lot of corporate lawyers and executives have a lot of anxiety about their positions, and that depending on how litigation may turn out may affect their careers and their positions in their companies. So those are things that, again, you need to ask very carefully, but you know, these are intangible interests which have nothing to do with the merits of the case, but may have everything to do with where they're going to settle or not, or how they're going to settle.
I always tell people,
I'd be curious.
it's always emotional. Even if the people in the room had absolutely nothing to do with causing the problem, the people in the room may have been told by their superiors, I want the case settled because we have a shareholders meeting coming up or whatever. And you're absolutely right. Their bonus or performance review depends upon them getting it off the corporate plate.
Yeah.
Michael.
Yeah, I would be curious as to how often parties in practice are willing to admit that they have emotional or non-monetary costs that they're considering. I mean, first of all, it's an admission of weakness for a party to say, I'm scared to go to trial, or I can't take the emotional stress or whatever. And it's tantamount to giving money away by admitting that, because you're giving the other side a chip, or you're giving the mediator a chip. So I've never asked the question, and I was just curious whether you get answers, or is it just asking the question that puts the idea in someone's mind?
Well, can I just throw out there something about the framing of the question? Because I think the way Steve framed it and the book framed it, although I actually don't remember this question from the book, but I might have just missed it, this sort of, what are these things worth to you? I've never asked that, and I actually would be concerned to ask that, to try to uncover intangible costs in that way. I could imagine might feel like almost like an assault. I mean, for some of the reasons, Michael, that you just said, which is it's an admission of weakness. Are you giving money away? But I find almost in every case that parties' sort of non-monetary needs come out of the conversations that I'm having with them. So, what's it been like to be in this litigation? What have you been doing since you lost that job? Is there, is this positively or negatively impacting other aspects of your life? Different kinds of questions that sort of surface, like what else is happening here? And then, I mean, I've never said to somebody, what's it worth to get a good night's sleep back? But I have said, you're telling me that, $150,000 is something that feels like you wouldn't even consider. And you've also told me that you haven't slept a full night in the last year and a half. And I'm, is there a way in which you can think about how to reconcile those two needs, the need for more money and the need for sleep? I mean, how do you see us finding a way through this so that you actually get some amount of what you need in both categories? So to try to not, I've never quantified it. Maybe that other people have, so I'd be interested to know.
So you, Rebecca, in fact, have asked this question at some of the lunch meetings. So I'll remind you of it. By the way, I was not saying to anybody, what's it worth to you?
Okay.
That was a very gross shorthand. But the question that you said.
There we go. John was. Good.
But the question I've heard you say at the lunch meetings is, what would it mean for you to have X dollars, whatever X is, in your hand now? If you had X dollars in your hand now, what would you be doing tomorrow? Would you be going on vacation? To try to plant the positive, to reframe it. So not what are you losing by accepting less than you're asking for, but what would it mean for you positively if you did have that money in your hand today? What would you be doing tomorrow?
I want to address Michael's question in a couple of ways. First thing is, this is a conversation that certainly would happen in caucus, so you're not going to do it in front of the other side. I guess I think about something that Rebecca and I were talking about before we all started, which was this notion of normalizing that a lot of people have problems, that litigation is really stressful, that people lose sleep, it's damaging to relationships at work or in their home, or all sorts of things that may be relevant based on what they've previously said. And in terms of, I appreciate the framing that you've suggested, Rebecca, which is certainly a valuable one. I guess one other way of sort of picking up what Steve said was to say, well, okay, here you can get this value. It's worth to you, $10,000 so that you can sleep at night. So, this isn't what you're losing, it's what you're getting. You are getting, this relief from the anxiety. You're getting not having to worry about, arguing with your spouse. You're getting this or that. Now, whether that would work in general or with particular parties, you all, it would be a case-by-case thing and you would have a better sense than I, but I think it could be framed in a way that people would find it helpful, that it's sort of what they're getting and not necessarily what they're losing.
Before we have only about 15 minutes left, so I just want to say our code word for today is, not surprisingly, LIRA, L-I-R-A. That is the code word.
So I'm relying on you, Rebecca, to manage this conversation. So where should we go next?
Did you want to pick one of the 4 questions that I raised that might be interesting?
Actually, just asking the questions is a useful one, particularly since I'm old and I can't remember them all.
Yeah. So one was about heuristics and how can neutrals best use heuristics, understanding that we all have them, that most of us don't understand when we are operating out of our own heuristics and biases, and that many of us are resistant if somebody tries to raise that. So that was question 1. Question 2 was, well, I think we've actually addressed it. It was about encountering lawyer-client pairs who don't seem to have prepared properly, or where the lawyer has abdicated their ethical obligation to go through risks with the client, and what kinds of processes might be most effective there. Question 3 was decision trees, like that I don't like them, and I now know that you don't love them either. But so how to sort of what can you do to sell that as a methodology to people like myself who are a little bit skeptical and find them to sort of, they feel to me like like kind of fake math often. Not the general inquiries, which I think are very valid, but when they start to, branch a million times, it just starts to feel like a big hypothetical to me. The last was this ABA task force study, the recent one, which you mentioned, and this discrepancy between what councils seem to want, which is actually a pretty directive approach, sometimes a highly evaluative approach, where a mediator is up to 80% of council want mediators to suggest specific solutions, to pressure people for specific solutions. And on those same questions, a much lower number of mediators, 30%, feel like that wouldn't be effective. So how do you understand that dichotomy, and particularly how to understand it in the context of self-determination?
Sure.
So those were the 4 questions.
Yeah, I think actually the first 2 we've already
touched on.
So let me talk about the 3rd and the 4th. In terms of decision trees, people have very different views about them. Some have the view that Rebecca just described and are very wary. My co-authors and I did a presentation for the CPR annual meeting before the virus hit, and a number of people had pushback about all the reasons that they were very uncomfortable about decision trees. Some along the lines of what Rebecca said, they can actually press people to entrench their positions, because it seems, you come up with this number and it seems like that's the right number. On the other hand, a lot of people are, and some people find it very useful. I went to the ABA conference, I guess it was 2 years ago. We were working on the book, and I was at 2 different panels where there were lawyers talking about cases, and these were major civil cases. There were 9 lawyers in these 2 panels, and I asked them if they used decision trees. 8 of them said no, essentially they'd never use them if they could ever help it. The 9th one was an inside counsel at 3M. I guess this was last year in Minneapolis, and she said she wouldn't use them, but her clients were all engineers. They used decision trees for their work, and they insisted that she use them for hers. So a lot of people just really don't like them, and if it was me, I wouldn't use them either. The point that Rebecca said, and what Michaela and Heather and I came up with for the book, is use them or not, and even the simple framework that we suggest has many of the same problems as a decision tree. I mean, basically you're just collapsing a decision tree into a simple framework, and it has some of the same problems. And regardless, even if you don't use it, we think it's helpful to have the analytical process of trying to identify what the major contingencies are, the uncertainties, and trying to get some sense, at least for your own internal assessment, of what the probabilities are and what the consequences may be. So some people like them, some people don't. One other thing, and then to Steve, when I wrote my first book on Warren with Planned Early Negotiation, I interviewed one guy who just loved them. He used triage, I'm not sure how you pronounce it, and he was using it all the time. And then I talked to him in the context of writing this book. I don't really use it so much anymore. So it's not something I particularly would recommend unless, one, you're comfortable with it and you think that it would be helpful in a particular case. Steve, you wanted to jump in.
Yeah, just an observation. I'm not surprised to hear you say it was the 3M person and it was the engineers. And I would just, I suspect, I have no data to prove it, but I suspect that the antipathy is caused by people being uncomfortable with STEM topics, as opposed to any defect in it as a tool to help resolve mediations.
I think that's part of it. And I think also there's a sense, which I think is really a valid worry, which is that, you're coming up with funny numbers. You're plugging in all these assumptions, and, where do you get these numbers from? You're pulling it out of, some part of your anatomy that you just don't know. And part of it is you could do these sensitivity analysis and say, well, what if it's 50% instead of 60%? And then if you do all this, you get mush. I think that's the technical term. You get mush. So, use it if you like. Let me turn to the fourth question that you asked, because I think in some ways that may be a more interesting one for this group to discuss. And you all in some ways may have better answers than I do. My take on the differences in the responses to that survey are that lawyers often are desperate to settle, and that they have in some ways a lot more on the line to settling than mediators, although mediators obviously do too, because this affects their perception as being effective and whether people are going to hire them again to mediate, to the extent that that's a consideration that lawyers who are hiring mediators have. But lawyers, they may not tell you honestly what their assessment of the probability of success are, but they may know in their heart of hearts that there is a big chance of losing, and that they're desperate. And also, not unlike the case where you are on the fly on the wall, they've been telling their clients, for a long time that their case is very risky and that they should settle now and take the money and run. And I've heard many reports about that's one reason why lawyers often want mediation. They want mediators to tell the clients things that they've been telling the clients all along, but the clients aren't buying it. And they want somebody else, particularly someone who's a neutral. So I think there's this kind of desperation for getting cases settled. And I think there's also less of within the mediation community, there's a kind of ethos and set of ethics about what's appropriate or not. And I think lawyers who haven't been trained as mediators don't have that sensitivity or appreciation. So those are thoughts off the top of my head. What do you all think?
Well,
Jackie.
Sorry, Jackie, go ahead.
Jackie.
Go ahead, Jackie, sorry. Jackie, please, go ahead.
Oh, I apologize. Can you all hear me?
Yep.
Yeah.
Oh,
I can't.
now we can't hear you. We could there for a minute.
Oh,
There you go.
okay. When I read this, it struck me that as a litigator, I participated in many mediation sessions, both private and also court-sponsored. And I, as a litigator, would be very frustrated when the mediator would not put pressure on both sides. I expect them to go to bat for me alone, but I expected them to dig in. I expected them, as Rebecca said earlier, I've done some aviation cases and a lot of aviation cases, and those comparable wrongful death verdicts, like I would be frustrated if he or she would not roll up her sleeves and get to the work. After all of everybody's had their chance to talk, the cathartic, active listening that we were all talking about, those individual, 4 hours listening to one side's perspective. And then I went to mediation school, and as a mediator, I will be honest, in front of Rebecca, my inclination is at the appropriate time, especially if the mediation has lawyers representing the clients. If I'm invited to, I'm very comfortable in that role. But as a mediator and a mediator student, I kind of wait until I'm invited to go on the dance floor. But once I get invited, I'm in my comfort level, because as a practitioner, I found it so dissatisfying. And actually, sometimes I thought, well, you're not doing your job. Okay, get in here, get in the mud with us. Not one side, not the other, both. But I don't know if I'm breaking all of my mediation training, and I probably.
That's it, you're fired, Jackie.
That's it. Mark, you had something to say.
Well, I don't know the particular wording of the ABA task force question, but linking back to the very first question I had is, I wonder whether some of this discrepancy is that lawyers want the mediator to give an evaluation, to recommend a proposal, because they're 90% sure that the mediator is going to agree with them.
Oh, interesting.
Right. And so I've always thought, what's the follow-up question? Do you want that candid assessment even if the mediator disagrees with you? even if the mediator thinks the other side's likely to win. My guess is, knowing most litigators' psychology, the answer is no, they wouldn't hire the mediator again. And it's part of this, like, overconfidence of lawyers and this lawyer psychology where, sometimes in the first caucus, they'll say, Mark, look, we hired you. You're a really thoughtful guy. And tell us, what do you think? Who's going to win? And I'll never answer that question, especially early on, but I get it that they're so sure that they're 90% likely to win, and they think that's what's missing in these settlements, is that the mediator won't get on their side.
That's actually, Mark, that's such a fascinating twist that I hadn't, all I read was what was in John's book. Maybe at some point I read the study, but it's too long ago. But I don't recall, I don't know, John, if you do, whether they asked a kind of qualifying question, like, would you want the mediator to do this if he or she agreed or disagreed? I mean, I think it's a really astute observation about the way, because Jackie's saying, I mean, yes, she wants a mediator to get in the muck with her. Jackie, you're actually sounded like what you were saying is you would want it no matter what, because you want to have a kind of intense, high level conversation about the specifics. But I think there is also that, your point, Mark, which is, if you knew the mediator was going to say, like, actually, I think you're sunk, you might as well, I don't know. Yeah. Steve.
Steve, and then I wanted to say something.
Yeah. Oh, I'm sorry, John.
You go, Steve, then I'll jump in.
You'll wrap us up, John.
I had a mediation. I think it was a Southern District mediation, and representing one of the parties was another Southern District mediator. And during the first caucus session, at the end of their presentation as to why they were going to win, this fellow said to his clients, of course, if the mediator were to say he disagreed, we'd have to rethink our position. Now, when have you ever heard counsel say that? Guess what? Yeah, we settled it. Okay, the end of the second day we settled. It was a clear invitation. So you have to be paying attention. So Mark, every once in a while, counsel, for whatever reason, and there's a long list of reasons, does not want to, is inviting the contrary view because he or she, for whatever reason, has said it and the client's not listening, or he or she doesn't want to say it, or something in between.
Yeah. So we have 3 minutes left, but John, I think it's totally appropriate that you have the last word here. So go ahead.
All right. So a couple things. Your question, Rebecca, about whether we asked that follow-up question. This was a survey, and we didn't get into that. This was as part of. We also did a series of focus groups, and we got reactions, although, the majority felt that they wanted these strong steps. There was a significant minority that didn't. And so in the report we had, some people said along the lines of what Jackie said, if you don't give me an evaluation, what good are you? That's the reason we hired you, you fool. So do it. And others said, you do that and you're going to screw up the mediation. So, part of the lesson is paying attention to what it is that people want. And in terms of Mark's assumption, which I'm sure is true in some cases, that what they really want is validation, I can imagine, and I assume that in a significant number of cases, the lawyers in their own minds aren't sure. They feel sort of confident, they think they could win, but it's hard to tell. If you tried a case 100 times, who knows what would happen? And so they're looking for a real candid assessment. So, and what we say in the book, I've got another talk lined up about integrating or combining, facilitative and evaluative mediation. And basically it's along the lines of what Jackie was saying, which is, doing these other things first. And if and when it's appropriate, which would be kind of later in the process, if the parties would like you to do it, then that's one thing. And if they don't, then don't do it. And certainly if they say don't do it, then don't do it. But in some cases, I think it's appropriate. Now, I know that there's this I don't know why there's still this debate about facilitative and evaluative mediation and why people have these strong ideological commitments to them. It seems like this is something that can be mediated, can be resolved, can be integrated, and yet people have these very strong views about it. So anyway, I think that good mediators can work that out, and part of that is having a good conversation with the lawyers and the parties about what it is that they're looking for, particularly at the outset, but also as the process goes along.
Well, it is exactly 1:30. I just want to thank John Landy for joining us today. And it was just really rich to have you here. It definitely added to our conversation. So, and thanks to all of you for also being here.
My pleasure.
Cheers. Thank you so much.
Thank you.
Yeah.
Everybody stay safe.
Yeah, you too. You too.
Bye.
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 Bye.